Ladies and gentlemen, thank you.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And my confidence level now on Kohberger walking is up to about 97.8%. That's right. And yeah, I feel kind of bad for especially Steve G, because he left me some comments yesterday in my video. And I don't know how many people's videos Steve leaves comments in, but he sure, likes to leave them in my videos for some reason. I mean, I don't know if maybe, I'm maybe one of those biggest obstacles out there to the information that comes along in this case. And it frustrates me because, and let me just say this, I like the Custody Queens and Ron. I think they, have a good channel. They've brought some good information to the community. But when I watch their coverage of the case outside of the interviews, it really get kind of sad because, I mean, they're the only real attorneys we have that's keeping an open mind in this case. And instead of diving in on the things that they have expertise on, like the law, I see them do the clickbait videos, listening to the college students give interviews that have nothing to do with the case, in my humble opinion. But that's just me. I just wish they would dive in on the law, and I implore them to go back and watch the video that I did the other day on their interview with Chatrie and what he talked about from a legal standpoint as it relates to Garza, Chatrie, Carpenter, the IGG, checkers, not chess. Go look at that and actually break it down from your law perspective, because in this video, I'm going to do much of the same, and I'm going to show you why Bryan Kohberger is going to walk. Because again, I get these comments from Steve G, and I feel bad for him because I don't think anybody around him is either competent or being honest with them, because they seem to take little pieces of what, like Chatrie said, and just try to run with it like it's the facts and like it ends the discussion. And I'm sad for them when this thing happens, because now I'm going to show you some things that are going to be real, why they're real, and how they apply to the overall end game. And for people out there to think that the Bryan Kohberger defense team was trying to hurt Bryan Kohberger, was incompetent, they are literally playing checkers while the defense team was playing chess. And I'm going to give you another example of it in this video. Because one of the things we heard Chatrie say, and he is right, and I'm going to show you that in this video, is that they had Bryan Kohberger's name long before they got the results back on the IGG, but actually not too long, just about, 5 days maybe longer than that though, because of the grand jury subpoenas from that federal grand jury that was in operation subpoenaing things for the FBI before Mallory ever filed his first search warrant. Oh yeah, I'll be able to show you that rather definitively in this video. But it remains to be seen, not really for me because I understand it, but why wasn't any of this ever brought up to the public? Why wasn't any of this ever brought up? Well, I'll give you the reasons for that as well. And why that new Supreme Court ruling on Chatrie is going to be the final pass in this thing for Bryan Kohberger. He will walk. People out there will be mad because they will assume Bryan Kohberger is the guilty party and he walked on a technicality. At this point, I don't care, because that's step number one. Step number two is to put focus on the investigation so they actually have to tell the truth. That's our duty. First duty is get the kid out of prison because he's not guilty. I don't care what reason that they have to use to do it. But hold on to your hats, folks, because I'm about to show you how they had Bryan Kohberger's name on a document before the arrest and why they did not ever bring it up to us. Are you ready? Roll.
It states that very clearly in Section 5. Before an agency takes on IGG, you're supposed to eliminate all investigative leads. Bryan Kohberger's name was in a report and was the most viable investigative lead in this case before the IGG results were done. So I want to start this conversation with IGG wasn't required. That's not the only way to get to Bryan Kohberger in this case. And I think that's really important for the people to say, I'll never believe Bryan Kohberger did this case. He was already on the radar. And I think they would have got to him. And man, if they would have got to him that way, this entire case changes.
You know, it's crazy how these things that I've brought up in a way to show how this was absolutely wrong turn out to be one of the things that actually is going to have the biggest impact in this case. But I've already covered this in our new expert report, one of the expert reports from the state. They go into the fact that on March 20th, some customer that was using Bryan Kohberger's account, they can't tell us who because his mother and father both used the same account, but the account was in Kohberger's name, and everything that was ordered from that account did ship to Albrightsville, Pennsylvania address. But they bought a gift card, somebody did, on Amazon for $130, and that was on March 20th. And then on March 21st, that same account purchased the K-Bar U.S. Marine Corps fighting knife straight for $86, and it was shipped to the Albrightsville, Pennsylvania address. Now, here's what we have to understand. Number one, it was a K-Bar fighting knife straight, which I've gone through and the defense expert went through and showed where the knife used, at least one of the knives used in the crime, if it was one knife, then it had to be a knife with a serrated edge because it had fine striations and scallops. And this knife that Kohberger bought was straight. So, I mean, they were searching for the wrong knife that fit the sheath from the beginning. But it doesn't negate the fact that Bryan Kohberger's household account in Bryan Kohberger's name did purchase a K-Bar knife on March 21st, 2022. Why is that important? Let me explain. Because when you go to the original search warrant of Amazon by Detective Mowry, he asked for all of the sales that were made by Amazon of that particular knife from January 1st, 2022 to present. So he searched Amazon for every knife that was purchased by Amazon. I mean, that was purchased through Amazon from January 1st, 2022 to present, which was November 26th, as I'll show you. So that means that this knife that was purchased by the Kohberger account on March 21st was on the list on the return of that search warrant. This is how Bryan Kohberger's name came up in the investigation. But for some reason, we've never heard this, have we? Right? They wanted all the account information, order details, payment information, all customer interaction records between Amazon. They wanted it all for everybody that purchased those knives, not just Kohberger's household, but everybody that purchased Amazon K-Bars from January 1st present. Now, we know that Mowry filed for that warrant on November 26th. They got it back on December 8th with all that information. So at the very least, if this was all on board and this is all that we were able to see, we would know that Kohberger's name came up in the investigation before the completion of the IGG due to the purchase of the K-Bar. Yeah, this is what Chatrie is talking about. Now, this is where things get interesting because later on, after the arrest of Bryan Kohberger, the same gentleman, Lawrence Mowry, files a search warrant for all purchases made from March 20th, 2022 through March 30th, 2022, and November 1st, 2022 through December 6th, 2022. Now, why did he do that? He got that information back on May 8th. Why did he do that? They'll tell you that because they wanted to see all the click activity. Would have happened earlier in November when they got the first warrant back. So why did they do two search warrants to Amazon that essentially gave them the same information on Bryan Kohberger? Once during the investigation before they had his name, and once after the investigation. That has been a bone of contention for the defense this entire time. And if you've paid attention to this case the way that I have, the defense even brought up the fact that it was very odd that Michael Douglas received the search warrant information and gave it to Mowry after Mowry searched this information. There was always some contention around why did they do this second search warrant when they already had the first one. Here's why that is in contention. Because knowing this now, at least once they got the IGG back, knowing they had the list of the people who purchased the K-bar, and they had the Daniel Tiango queuing the car on November 29th, but we know that Daniel Tiango never got with Payne. Payne had to go back and get with Tiango on December 20th. Lana even uncovered all the email and communications between Payne and Tiango. Payne has testified in court he didn't know anything about the Tiango incident until December 20th. But with all of that, there is never once any mention of the Amazon warrant return in the PCA that showed Bryan Kohberger's family account purchasing this K-bar. Or is actually Bryan Kohberger's actual account purchasing this K-bar. Why was that not put anywhere in the probable cause affidavit? You know what? What's interesting is the two things that are never in the probable cause affidavit that we know now law enforcement did before the arrest of Bryan Kohberger is the IGG, and now we know it was the Amazon warrant. Why were they hiding these two things in the case all the way up to here recently? Well, the reason they were hiding it becomes very clear, and the reason Bryan Kohberger is going to walk because of it becomes even more clear. And it's called the Fourth Amendment, y'all. You see, the reason that they wouldn't have brought up the original search warrant to Amazon is because the prosecution team knew if they did, the Amazon warrant would likely be suppressed, and due to that suppression, they would be faced with fruit of the poisonous tree once again. So they just kind of hid it. But the core legal issue is the Fourth Amendment's constraints on warrants, the exclusionary rule, and doctrines that can clean or isolate evidence, independent source, attenuation, good faith reliance. The described sequence raises classic risks of overbreadth, particularly defects and potential taint, which explain why results from the first warrant might never be relied upon or disclosed in the charging or suppression posture, although it was brought up in suppression posture. That's where the key of this thing comes into play. Fourth Amendment baselines that apply. A search warrant must be supported by probable cause that the places or things to be searched or seized will yield evidence of a crime. And it must particularly describe those places and things. A demand for the identities of every person who bought a specific model of knife from a national retailer over nearly a year is a bulk request for third-party business records. Now, this went on to be litigated in a suppression motion by the defense in their motions to suppress when we get around the time of trying to suppress the IGG. And here's why it's important. Because of the arguments the defense team used and the objections they preserved when trying to suppress this warrant. And it let us in on some other things. And we have to go to the judge's order on the suppression motion for Amazon. And you'll notice it says Amazon subpoena and search warrant. At some point in the investigation, now the judge doesn't want to clarify when, he just says at some point, the FBI located an Amazon account associated with defendant. It served a federal grand jury subpoena upon Amazon Inc., seeking order history records. And it says little number 9 there. You go to 9 and it says the FBI's subpoena is not in the record. Why is it not in the record? Because the FBI subpoena was issued by the grand jury. That's how they get subpoenas issued with the FBI. They use a federal grand jury to subpoena the records. The federal grand jury was already convened before December 8th, y'all. They were using a federal grand jury that was already convened because that federal grand jury was already investigating a big drug trafficking network. Give me a break. But in seeking the order history records, Amazon responded by providing the FBI with defendants' Amazon subscription information and purchase history from January 1st, 2022 to December 13th, 2022. See States Exhibit S4 to Amazon objection. Now, why is this key right here? Because look at the words of the judge. The FBI gave the information and purchase history not from March 20th, 2022, but from January 1st, 2022 to December 13th, 2022. Remember what I just showed you. The original Amazon warrant by Mowry asked for information from January 1st, 2022 to present. The additional warrant that was filed later in 2023 asked for the information from March 20th, 2022 to December 6th, 2022. Not anything before March 20th. So the warrant return that the judge is referring to is the first warrant that was issued on November 26th by Mowry for January 1st, 2022 to present. Now, why was Mowry searching this information from Amazon from January 1st to present when the grand jury subpoena by the FBI had already produced this information, according to Judge Hippler? Again, the federal grand jury subpoena provided information from January 1st to December 13th. State Exhibit S4 to Amazon objection. After receiving this information, Mowry applied for and received search warrant for records retained by Amazon for defendant's account regarding customer click activity. Yeah. And he asked for the date range of March 20th through 30th, and then it talks about the second warrant. Now he goes into the conclusions of law, and he's going to group everything in together, the IGG, the AT&T, the Amazon. But here's where it becomes critical. Defendant does not have a privacy interest in the subpoenaed records protected by the Fourth Amendment of the Idaho Constitution. Why? Because the judge has ruled based on the defense's objection as it relates to, guess what? Carpenter versus the United States. The subpoenas did not violate the defendant's Fourth Amendment rights, citing his protection or his understanding of the protections under Carpenter. Carpenter. When he really gets to the breadth of his order down here, I mean, he starts later in Carpenter. The court was careful to limit its holding in Carpenter. Consequently, he asserts that under Carpenter, however, unlike in Carpenter, exhaustive chronicle of location information at issue in Carpenter. And moreover, this information was not simply passively powering on a phone as was the CSLI in Carpenter. Everything around the judge's order on this suppression motion relates to the defense's bringing up Carpenter as the reason for the suppression. Fast forward to today. A simple AI search, Steve G. You ought to try this sometimes. And don't make it be anything, that's going to give you any kind of biased results. You ask it just in a general way. Did the Kohberger defense team preserve their objection to the Amazon search warrants under Carpenter? Yes, Bryan Kohberger's defense team preserved their Fourth Amendment objections to the Amazon search warrants and subpoenas by filing formal motions to suppress based on Carpenter versus the United States. The key words here is preserved. This is why I wish the attorneys that cover this case would cover real things and not, clickbait interview stuff. The bathroom downstairs didn't have any shampoo in it. Yeah, it did. If you look the pictures, Turvey was just lying about everything. But we're forced to hear questions about Crocs instead of the law. Now, follow that up. Would the new ruling under Chatrie by the U.S. Supreme Court give the defense a stronger argument under Carpenter for these preserved objections if the case was reopened and a new trial declared? Yes, the Supreme Court's ruling in Chatrie versus the United States gives the defense a significantly stronger argument under Carpenter for any preserved objections regarding digital location data. Under the June 2026 decision in Chatrie, the Supreme Court held 6-3 that law enforcement conducts a Fourth Amendment search when it uses a geofence warrant to compel a company like Google to hand over location history data. But if you apply the new ruling under Chatrie as it relates to Carpenter to that specific case and that specific circumstance, it also extends under IGG, and it would slap the living crap out of you under the Amazon broad search that they try to hide this entire time. This case is over.